Good morning, and thank you for joining us. My name is Austin Parrish. I'm the Dean and Chancellor's Professor here at the University of California, Irvine School of Law. On behalf of the faculty and the staff, welcome. This is our 14th annual United States Supreme Court Term in Review, and it is going to be a fabulous discussion. I have a couple of just very brief announcements and some thank yous. So I wanted to start off by thanking the amazing staff at the Barclay Theatre and also Leslie Dodds, Josh Larson, and the entire law school team that have been working feverishly behind the scenes to make this successful. And so a deep thank you from behalf of the law school to them. One of the things that makes the law school particularly unique and distinct among law schools in the nation is how deeply connected it is to the local community. I was speaking with a former Bar Association president who told me a few weeks ago that in his opinion, the two most important events in Southern California was the founding of the federal courthouse and the founding of the law school. That was music to my ears. But it has certainly been true in the last 15 years of law school that part of our success has been the deep engagement and support of the community. That's true with our pro bono and public interest programs, where students work with over 100 organizations, law firms, government entities each semester. It's true by the number of scholarships created by firms and individuals to support our students to reduce the cost of education. It's true with the large number of our graduates that go on to be leaders. Currently, the president of the Orange County Bar Association, the Thurgood Marshall Bar Association, the Orange County Korean American Bar Association are all our grads. All of that commitment to the community, though, is perhaps best illustrated by the sponsors of today's event. Reza Torksada and his family have been tremendous supporters of the law school since its founding. TorkLaw has sponsored this event in the last 5 years. Reza and his family, Reza currently chairs the Dean's Circle. His family has created a very generous scholarship to support our students. So many thanks to our sponsor. Without TorkLaw's generosity, this event would not be possible. So thank you, Reza and TorkLaw, for their support of today's program. But one of the things that has made the law school incredibly successful has been the amazing support from the local community and the legal community in Orange County. The other part of it is the amazing faculty that we have at the school. Some of the best thinkers thinking about the most important issues of the day are not in DC or Boston or New York or Chicago, but are here in Irvine and in Orange County. Two people that represent that astonishing, amazing breadth of skill and expertise are the two faculty that organized and oversaw this event, Professor Mario Barnes and Professor Carrie Menkel-Meadow. They've brought together an amazing panel, which will be introduced in a moment. But if we could have a thank you to Mario Barnes and Carrie Menkel-Meadow. And as those thank yous concluded, I want to introduce the moderator for today's panel, Professor Carrie Menkel-Meadow. She is a founding member of the UCI Law faculty. She is a distinguished professor at UCI, and she's a Chancellor's Professor of Law at the law school. Many of you know Professor Menkel-Meadow. She has taught at Georgetown, UCLA, has visited at Harvard, Oxford, and a number of other schools. She has not only influenced conversations in many fields, but she has transformed them. Please join me in welcoming our moderator for today's event, Professor Carrie Menkel-Meadow.
Thank you, Austin. Welcome, everyone, to our 14th Annual Supreme Court Review in what is the 15th year of the law school. Seated next to me is our founding dean, who I will introduce in a moment. But it's really our great pleasure to be with you in what unfortunately may not be such a pleasurable hour and a half. Shortly, you are going to hear words like improvidently granted, standing remanded. A lot of the cases were, in my humble opinion, punted. Nevertheless, as you will soon hear, the cases that were decided, and there are many of them for us to discuss this morning, have the potential to wreak havoc in the lives of many of us, probably millions of people. So it's a kind of sad morning for us to review what the Supreme Court has done. We have some questions that you have submitted that I hope we have time for. We have a lot of cases to talk about, and a lot of it has to do with what's the future of the court and the future of our country based on some of those decisions. I want to start briefly with a very short story. As you just heard from Austin, I was on the faculty of Georgetown Law School for 15 years, and I had the great pleasure when I was on the faculty to moot many of the cases that appeared before the Supreme Court. If you ever get to Washington, you want to visit the Supreme Court, but Georgetown has a mock-up of the Supreme Court itself, and we, every year, mooted at least one side of every single one of the cases that went before the Supreme Court. So I had 15 years of mooting a lot of the major cases in a very, very different time. I've been here for 15 years, so it was a long time ago. In 2005, John Roberts was temporarily my colleague. He was an adjunct professor at Georgetown, and he was in fact teaching in our London program when he had to fly back to prepare for his confirmation hearings. And I mention this to you because he was very grateful to Georgetown. He gave one of his first public addresses at our graduation at the end of his first year of service. And he said in that speech, probably the best graduation speech I have ever heard, and I've been a law professor for 50 years, he said he was going to try to be a consensus builder on the court. And his plan was to decide every case as narrowly as possible to try to create the biggest consensus that he could. Never in my experience as a law professor did the professors process off the stage and begin to talk about what the graduation speaker had said, substantively. Is it a good thing to decide things narrowly and create consensus? Or do we look to the Supreme Court to express and decide and explain our deepest values? So we had a very spirited discussion as faculty. Alas, 1 year later, Linda Greenhouse, the New York Times Supreme Court expert, did a follow-up on Justice Roberts' speech, and that year had the highest number up until then of 5-4 non-consensus decisions. Sadly, this year, we have almost every one of the cases we're going to talk about this morning 6-3. And as you're about to hear from many of us, many of them, not all of them, but most of them on ideological grounds. So we're going to explore some of the legal issues with you. But I want you to be thinking about, as some of you have asked, what's the future of the court? I will just briefly mention, as some of you have read in the papers, I'm also an ethicist. I've spent 30 years of my professional life trying to get an ethics code for the Supreme Court. And as some of you know, there have been questions about some of our justices and their spouses and some of their activities. For those of you who don't know, the Supreme Court is not subject to any ethical rules. Federal judges are. We have some in the audience. They have to recuse themselves. They have proceedings about when they can and can't hear cases. The Supreme Court does not. There was a proposed bill in Congress this year to change that. It didn't pass. And as I'm sure Dean Chemerinsky would tell us, even if it passed, certainly with this court, there'd be a question of separation of powers. So we're going to hear about what the court has done to us and for us. And you should all know that almost everything they've done this year has been pretty controversial. So let me briefly introduce our incredibly distinguished panel and thank them so much for coming. It's really wonderful to have them. Jennifer Chacón, my former colleague. The three of us here were part of actually all of us here, founding faculty, so we're having a little reunion up here on stage. Jennifer Chacón is the Bruce Tyson Mitchell Professor of Law at Stanford. She has the distinction, I think, of being the one professor who's taught at the most UC law schools of anybody in the country. She began at Davis.
You just need Hastings,
Right,
right?
no, University of California, San Francisco
okay.
Law School. She began at Davis. She was with us for 9 years at Irvine. Then she went to UCLA, where I taught for many years. Then she went to Berkeley, and now she's at Stanford. She's an expert in immigration law, criminal law, constitutional law, and if you're interested, she will be signing books at 11:30 in the lobby of her new book, Legal Phantoms on Immigration Law and Policy. Outside, go quickly if you want that, because she needs to leave pretty soon. Next to her, our founding dean, Erwin Chemerinsky, who probably needs very little introduction. Erwin and I met 40 years ago? A long time ago, when we were both brand new professors in Los Angeles. Erwin at USC and me at UCLA.
We were in middle school then.
We were just talking about it. And as many of you probably know, he's written 15, 16 books, many books, 20 books, right? And he too will be signing his latest one. It's not his latest one, he's got a couple coming out. But Worse Than Nothing, The Fallacy of Originalism, I strongly recommend it. It's a great book, and he'll be out there signing at 11:30 when we conclude the program. In addition to his books, he's written over 200 articles. He's argued in front of the Supreme Court. And most amazing, there are many amazing things about Erwin. If you can't follow everything we say today, the minute the Supreme Court decides something, this man has an op-ed within 30 minutes. Some of his op-eds are in your materials for those of you who are getting MCLA credit. And I just want to personally thank Erwin so much for coming to join us.
Thank you for having me.
To my left is my wonderful distinguished colleague, Mario Barnes, who is also here at the very beginning. He's a Chancellor's professor at UCI Law and the co-chair of our Center on Race, Equality, and the Law, and is also an expert in criminal law, national security law, military law, constitutional law, and his booming voice fills my heart with love. He's been my neighbor for all the years except when he left us briefly to be the dean at the University of Washington Law School. And we're so glad to have Mario back. Thank you, Mario. Next to Mario is one of our newest colleagues at UCI, Courtney Cahill, who is also a Chancellor's professor, an expert in constitutional law, equality law, sex equality law, and LGBTQ rights. And Courtney's on our corridor too, so we have a very distinguished panel of professors to be discussing all of these cases. And as you'll hear in a few moments, she's an expert in reproductive rights, some of the important cases that were sort of punted this term. We'll hear more about that in a moment. Some of you will be interested to know what we think is going to happen. And finally, we have Kelly Perigoe, who is a partner at King & Spalding in Los Angeles. We think it's very important on these panels to have people who actually practice law. Some of us have. Most of us have had some practice experience. Kelly does both federal and state appellate and trial practice, and she's going to have a little bit of the, what does this all mean for practicing lawyers, as well as reviewing some of the Supreme Court cases. So that's our wonderful panel. Thank you all. Bear with me, we have a lot of cases to talk about today. There'll be no Q&A from the audience. We've asked you to, if you have some questions, to put them on cards, and hopefully we'll have enough time to get to some of those. No questions and answers from the audience, alas, because we have so much to talk about. So, we begin. It's an election year. Mario Barnes, Alexander versus South Carolina NAACP. Tell us about what's happening to voting.
Well, so, I mean, I think most people might agree that the status of voting in this country has been in some peril, both inside and outside of the court in recent years. But in some ways, Alexander is a more typical voting case in that what happens is after every census, we have redistricting. It belongs to the state legislatures to redistrict. And here, what we had in South Carolina was 2020 census in which, if you look historically, that had one significant district that had a very large African-American population, but after the 2020 census, what you had was this District 1 that had a fairly large population, but also now so did District 6. And so they sort of had a place where you might get different voting results because the population had changed. So what happens in their redistricting, they hire this person who becomes responsible for the redistricting plan, and what they decide is they want District 6 to remain politically conservative. They want it to be Republican. They want it to be overwhelmingly so. So they seek to draw a map that will create the political advantage they want. So the state is allowed to do that. The state, the court basically says we should show deference and believe the faith is acting in, the state is acting in good faith, even when they move counties and folks around for the purpose of seeking political gain. That's not a problem for the Constitution. The problem for the Constitution is when you do so, and it creates a racial problem or racial disenfranchisement based on what you do in the map. And so in their efforts to make the district overwhelmingly Republican, their solution for doing that was to remove mostly, disproportionately, a significant number of black voters from District 6 into District 1. And so doing, they reduced the number of black voters in District 1 by 60%. And so the claim, of course, comes from the NAACP and what was a previous resident and voter in District 6. The claim is you can't do this actually because race has played a predominant role in the way in which you've reordered the districts. In other words, you are racially gerrymandering, and that does create a problem constitutionally. So in the district court, they heard from the map drawer, they heard from 4 different experts on the new constitution and the map, and the expert data all seems to suggest that while it was true that they had a political motive in why they moved voters, that the method they chose to achieve their goal substantially relied on affecting the racial population or composition. And so the question is, if you have this, I don't want to call it your political motive legitimate, but I'll say at least if you have this political motive that's not necessarily unconstitutional, alongside one for which race is the consideration, what happens when we have this correlation? And so it comes to the court. Some of us who were watching actually thought, given the testimony in the district court, how specific it was, how detailed the court was in making the determination that South Carolina had improperly considered race in service to their political goals. And because the standard was to reverse them, you have to see clear error, that it might survive. It did not survive. So what happens in the case? So the opinion is written by Justice Alito, and it's a 6-3, Carrie, with the conservative supermajority. And they do something that's really disappointing if you're a follower of a history of race and criminal justice in this country, which what they do is something we've seen in an earlier case many years ago called McCleskey. And what happens in that case is, even though there is strong empirical evidence of a connection between the race of a perpetrator, race of a victim, and the imposition of a death penalty, the court says in that case the existence of a correlation between race and some justice system outcome is not proof of causation that would lead us to believe there's an unconstitutional risk of race unlawfully affecting the system. Similarly, what happens here, Justice Alito essentially says, all you've really pointed out is a correlation between their political ambition and the fact that that group of people also happens to be disproportionately of one race. You haven't proven racial predominance in the way in which we've styled it in earlier cases. And the thing they then say that drives me a little crazy is they say, in order to invalidate this map, you would basically have to prove that there is no possibility that it is solely the political goal and not the racial composition. In other words, you would have to find some way to say, of these two things that are both affecting this, it is race rather than politics. And what anybody who does empirical work would say, it's very difficult to know that. Not everything exists in this kind of relationship of counterfactual where you can say one thing rather than. Both things seem to be true, right? It is both true that they were doing this in service to a political ambition, but to achieve it, they seem to heavily weight race in the process. That's actually what Justice Kagan says in the dissent. And the reason I bring up McCleskey is because ultimately they've now created a rule that feels like the rule in McCleskey. So in McCleskey, when they argued about the way in which race was impacting the system, the court reiterates a kind of holding from a previous case that says, well, it's not enough that legislatures considered this problem, understanding there was a racial component. You have to prove that they chose this system because of the racial consequence, not in spite of it, right? And so they've now announced a standard that seems very similar to that, which is if you have these sort of moments where you have political goals, but because of many social and historical factors, there is certainly a racial valence to party affiliation. But that alone will not be sufficient to raise a claim that you have racially gerrymandered some district. And so I'm at a place where I'm now confused on how I would prove a case of racial gerrymandering, especially when you think in South Carolina, the largest portion of African Americans are actually Democrats. As long as that's true, you are now going to have a very difficult time in proving that any gerrymandering that affects African Americans wasn't acceptable political rather than unacceptable racial gerrymandering. So people say, well, it's not the most surprising result. No, but it is a significant one, right? When you've now conflated two things in such a way that it becomes very difficult to ensure franchise voters based on now party affiliation surely being the basis of which so many more jurisdictions will claim, they made decisions and not race. I will say this, one of the things that bugged me is the standard that Justice Alito was bothered by. He says, well, we've overcome clear error, I didn't agree with, but he also says, in these cases, there is a requirement of deferring to the good faith of the legislature, and I just think, who the hell think these people are operating in good faith anymore? But still, so you want me to accept good faith, you want me to ignore what previously was a pretty high standard and clear error, and now you want me to sort of just accept that unless you have some sort of smoking gun that proves race was the true motivation, that you're not going to be able to argue in cases like that. And I would imagine we will now see in a number of contested states and jurisdictions moves that look like this, right? Non-contiguous large groups of people move from one area. One person did ask me, but doesn't that make District 1 now a sort of supermajority of black voters? It now has an inordinately large amount of black voters in a single district, right? So it means they're not diluted in District 1. The problem now is District 6.
And that's
also.
Clyburn's district,
Yes.
right? Thank you, Mario. I forgot to mention, and I should point out, Mario is one of the leaders in empirical studies in critical race theory. And what you've just heard is, for the social scientists in the audience, correlation is not causation. And the problem of trying to show motive in these cases when the motives are in fact mixed, potentially, and one can be covered for the other.
You can't have two thoughts at one time, it turns out.
Yeah, well, that's going to be clear. Stay tuned. There's going to be more of that. Thanks, Mario. So we now turn to two gun cases, and they have sort of different results. And so we're going to have two presentations, and then maybe we'll have our gun experts talk about how they might relate to each other. So we'll start with Kelly. Garland versus Cahill, bump stocks.
Yes. So I don't know that I'm a gun expert, but I have now seen 6 illustrations and a GIF illustrating
Yes.
how this works. So
Explain to the audience.
yes. So this is another 6-3 decision dealing with bump stocks, which I'll explain what those are in a minute. But the National Firearms Act of 1934 outlaws machine guns. And the statute defines machine guns as any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot by a single function of the trigger. And then in the 1980s, I believe it was, the act was amended to also include devices that can convert a rifle into a machine gun. And so the question before the court in this case is the bump stock such a device? And so what a bump stock is essentially is it's a device that gets affixed to a semi-automatic rifle, and when the shooter pulls the trigger, shoots a shot, the device harnesses the recoil energy and slides the gun forward against the shooter's stationary finger. And so as a result, it reaches the same kind of rate of fire as a machine gun. And in 2018, under the Trump administration, the Bureau of Alcohol, Tobacco, and Firearms issues a rule saying that a bump stock is a machine gun within the meaning of the act. And this is in response to the 2017 Las Vegas mass shooting, in which 58 people were killed, 500 injured, biggest mass shooting in US history. And the shooter used bump stock equipped rifles. And so in response to that, they say, ATF says, bump stocks are machine guns. So Cargill has 2 bump stocks. He turns them in under the rule. He's required to do so. And then he sues under the Administrative Procedures Act, saying that the rule exceeds ATF's agency authority under the statute. And so, as I alluded to earlier, the illustrations and the GIFs, so the Thomas majority in this case is hyper-technical about how these guns work, gets really in the weeds on how the text of the statute fits with the way that the guns work in real life. And what he says is there's 2 problems with the rule under the statutory language. The first is a bump stock doesn't operate to shoot more than one shot with the single function of the trigger. And how he says that is he looks at the gun itself and what the trigger is doing. So between each shot, the trigger actually does reset. And so he says that's not the single function of the trigger in the same way that a machine gun is. So focusing on the gun rather than the shooter. And then the other piece he says is it's not automatic because in addition to pulling the trigger, you also have to have forward force on the gun in order to keep it cycling back and forth. Sotomayor's dissent in this says, come on, there's no meaningful difference between a machine gun and a bump stock equipped rifle. I mean, at the end of the day, you've got a trigger plus backward motion on the trigger in a traditional machine gun, and in a bump stock, you've got the trigger and forward motion, but it's essentially the same thing. And she invokes the statutory canon, the rule against ineffectiveness, and says you can't read a statute in a way that enables people to essentially just circumvent it. I think what's really interesting about this case is the Alito concurrence, because it's really short and it kind of just says the quiet part out loud, which is he says, of course, the Congress that enacted this statute, wouldn't have seen any material difference between a bump stock equipped rifle and a machine gun. But the text says what it says. He says it couldn't be clearer, which is interesting because, of course, the dissent reads it differently. ATF read it differently. The district court and the 3-judge panel read it differently. But he says it says what it says. And he says there's a simple remedy. Just have Congress amend the statute. Which I think is also interesting because, of course, Thomas uses the fact that Congress tried and did not amend the statute to say that Congress, that this exceeds, the ATF rule exceeds the authority from Congress. But that's where we're left is sort of what can you do, because gun innovations are going to keep being such that it's really hard for Congress, I think, to stay ahead of them.
Thanks, Kelly. Stay tuned for that one. As you will hear in a lot of these cases, while some of the justices say the text is clear and we're just following the text, textualism, others say original intent is clear, read Erwin's book. The very fact that there's a dissent in almost every case tells you it's not quite so clear, neither the text nor the original intent, or we would be having this argument in print. Thanks, Kelly. Stay tuned, there'll be more of those. So, Jennifer, U.S. versus Rahimi. Kind of an interesting surprise for some of us. Erwin has a great op-ed on that one. For those of you who are interested, I think it's in our packet. Tell us about U.S. versus Rahimi.
Sure. I'm not a gun expert either. I should just disclaim that at the front, although I am from Texas, so I think that gives me the ability to talk about these things. Rahimi is an 8-1 decision, so it defies our typical split, at least in the trends that we've been talking about. Roberts writes for the court. There are a number of concurrences, most of which I won't really talk about, and then Justice Thomas writes the lone dissent, so we can see the interesting setup here. But in this case, the court reversed a Fifth Circuit opinion that would have invalidated a federal law that criminalized gun and ammunition possession by individuals subject to a civil restraining order. That is, someone who had been determined to, quote, represent a credible threat to the physical safety of an intimate partner or child, or relatedly had been prohibited from using force against an intimate partner or child. So there had already been a proceeding in which that had been established, and those individuals are barred by federal law from possessing guns and ammunition. So the Fifth Circuit held that this federal law ran afoul of the Second Amendment, as interpreted by the court in its recent decision in Bruin. So in reversing the Fifth Circuit, the court is backing away, I think substantially in some ways, from a test that it articulated very recently in its Bruin decision. So by way of a background, I'm going to give a little bit of background and then move back into the case. So less than 20 years ago in Heller, the court found that the Second Amendment provided an individual level constitutional right to bear arms. This was pretty novel, but has become sort of the accepted baseline against which all of the gun litigation that's proceeded since that time operates. So we have an individual right to bear arms under the Second Amendment, and several years later, that right was incorporated as against states and localities. And what this means effectively is that it's hard for the federal government or a state or a city to criminalize gun ownership. Hard, but this case tells us, but not impossible. With Bruin, the court really kind of made it this difficulty even more difficult, really raised the bar. The court wrote, when the Second Amendment's plain text covers an individual's conduct, that is, the individual right to bear arms, the Constitution presumptively protects that conduct. So we start with the presumption that the individual's right to bear arms cannot be trumped in any way. To overcome the presumption, the court tells us the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. So that's the framework that Bruin gives us. Is it consistent with the nation's historical tradition of firearm regulation? Now, anyone who studies history knows that there's probably not one answer to any question about what the nation's historical tradition is, and that's what makes this test so murky, and that is one of the reasons that the lower courts were such a mess when it came to trying to decide how to apply Bruin to gun regulation. And that really brings us to Rahimi. There is probably no history and tradition of disarming domestic abusers at the founding, given that domestic abuse was really not really regulated at the founding. So the Fifth Circuit held in this case that federal law in question in Rahimi must be unconstitutional under Bruin. There's no history and tradition of disarming domestic abusers. Therefore, the federal regulation is unconstitutional. The court in Rahimi this term backs away from Bruin, even as it purports to apply it. The Roberts opinion says we don't need to find an exact twin regulation of gun ownership at the founding. We just need to find something that's analogous at the right level of generality. So a gun restriction that doesn't precisely match a historical law, quote, still may be analogous enough to pass constitutional muster, end quote. So here the court notes at the time of the founding there were things like surety laws or going armed laws that were designed to disarm dangerous people, and the court says the federal regulation here is analogous to those things. Interestingly, Thomas dissents. He is the lone dissenter here, and I think he's actually fundamentally right that the court is walking back from Bruin and adopting a standard that is more amenable to gun regulation than Bruin's standard. But I think one of the things that's troubling is it's also not clear post-Rahimi how amenable the new standard is to gun regulation. How do we find the right level of generality for gun restrictions? When does that allow for states or localities or the federal government to regulate gun ownership? In her Rahimi concurrence, Jackson attacks the court's previous decision in Bruin. She says it was wrongly decided. She says that the resulting test had sowed a lot of chaos in the lower courts. And she writes, the rule of law, that ideal, key to our democracy, thrives on a legal standard that fosters stability, facilitates consistency, and promotes predictability. She worries that the court's decisions in this area are not serving that value, not offering good guidance to lower courts about what the law requires, not providing stability, not providing clarity. And I think her point about the rule of law in this case and in the area of gun regulation is one that's worth centering more generally today, because gun regulation isn't the only place, the only constitutional area where the court's decisions are increasingly parting company with those rule of law values she articulates of stability, consistency, and predictability. And I think we'll see those themes emerging across the cases that we're talking about.
Thanks, Jennifer. I don't want to force you to look in the crystal ball, but given all of that, what thoughts do you have about other efforts to restrict gun use connected to other things, like felons, for example, and those with mental health histories, as many of you know, lots of efforts to restrict the licensing and use of guns. Do you think this Rahimi tells us anything about where those are going to go?
So it's difficult to say. I think one thing we know about Rahimi is the facts were really bad for those who were seeking to challenge the regulation. And so it was, I think, very hard for this court to get behind the idea that someone with Zach Rahimi's history of violence that was sort of all over the record was someone whose gun ownership couldn't be regulated. So I think that made this case in some ways a particularly low bar and one that doesn't tell us a lot, doesn't give us a lot of predictive purchase on what happens with other efforts to regulate gun ownership. And I think that's really part of Jackson's point. That is that this is, we're still in the world where we are purportedly hearkening to history and tradition. We don't know at what level of generality we assess gun regulations when we're making those analogies. This opinion tells us a little bit, but doesn't tell us anything definitive. And I suspect we'll continue to see chaos in the lower courts, and we're really not. It will maybe depend on facts in some ways, and how cases are teed up when it comes to the Supreme Court deciding whether regulations are constitutional or not.
Thanks. Mario, do you want to weigh in on
I'm
this
just
too?
mad. Why don't you give the same amount of weight to the contemporary reality that you do to, a long ago history, which, if we certainly, the rights of women and people of color would not fare well in history. And Erwin has made some of this commentary vis-a-vis gun ownership. But I was looking at the data this morning before coming in that said 92% of women who are killed by gun violence are killed by people familiar to them, right? And so we have a problem in which there are more people who have guns than who are using them responsibly and who are posing a threat to people. And why can't we have reasonable regulation? Because, and I've heard Erwin say this, none of our constitutional rights are sacrosanct. Like the Second Amendment, the First Amendment, they are all subject to forms of government intrusion when the reasons are important enough. And I think you are right, Jennifer. We have just now entered into a territory because the individual case had such a parade of horribles. They were willing to have a carve-out, but they have not been willing to have the larger conversation about the danger posed from guns and the failure to regulate them. So I'm just, it's vexing.
And I'd go a little bit further. I think, in fact, even as it affirms the constitutionality of the regulation here, it also reaffirms the Bruin test. So it says it's applying Bruin, and it says ultimately at the end of the day we're reliant on those. So this was an opportunity for the court to step back from that, maybe to return to something that had a little bit more of a functionalist analysis, and it does not take that road at all.
Erwin, you said a little more in your op-ed. I don't know whether you want to say something.
I very much agree with both Jennifer and Mario. What's striking about Chief Justice Roberts' opinion is he never mentions the social costs of domestic violence, the human costs of domestic violence. It's entirely about how to reconcile this law with the original understanding from 1791. And I think it's crucial that this is different than any other constitutional right. It provides more protection for Second Amendment rights than any others. For all other rights, say fundamental rights like freedom of speech or protection from race discrimination, the government can act if it can show a compelling interest and no other way to achieve it. But Justice Thomas' approach in Bruin says, we're not going to look to whether or not there's a compelling end. He says 3 times the Second Amendment is an unqualified right, and the only regulations that are allowed are those that were historically permitted. And so what you have is a disagreement among the justices as to how to look at history, but ignoring what Mario is saying, the reason we have this law is we recognize the horrors of domestic violence in a way that wasn't perceived in 1791.
Thank you. Okay, and if all of that isn't depressing enough, we now turn to what may or may not remain of reproductive rights. So, Courtney, we're going to do 2 cases. I'll let you start with FDA versus Alliance for Hippocratic Medicine. Excuse me.
No.
So for those of you who were here 2 years ago when on this stage we had to deal with Dobbs, the Supreme Court did 2 cases having to do with abortion. And this is where we're going to see a little punting and moving away from deciding anything. So why don't you begin with FDA, which is, for those of you who don't know, the abortion pill methylphosphone case. Courtney.
Sure. So this is a Alliance for Hippocratic Medicine versus FDA is a rare example of unanimity on the court. So this was a consensus decision in an otherwise non-consensus term. So this case was about the legality of the medication known as mifepristone, which is the most common form, which accounts for more than 50% of all abortions in the United States, of course, only in those states that still allow abortion rights. So here, a group of pro-life doctors and activists that collectively are represented by this Alliance for Hippocratic Medicine argued that the FDA abused its authority under the Administrative Procedure Act when it, 1, approved mifepristone in nearly a quarter of a century ago in 2000, approved it for use in medication abortion, And two, they argue that the FDA continued to abuse its authority when it started to lift restrictions on the use of mifepristone, especially during COVID. The main restriction that the FDA lifted, of course, was the in-person requirement. So previously, the FDA had required a patient to go into a doctor to meet in person with a doctor in order to get the prescription for mifepristone. During COVID, the FDA lifted the in-person requirement and allowed the abortion pills to be shipped through the mail. So the doctors are arguing, look, this is an abuse of the FDA's authority under the Administrative Procedure Act. They found a sympathetic ear of a federal district court judge in Amarillo, Texas, who said the FDA exceeded its authority in not only in lifting the restrictions during COVID, but in approving mifepristone in the first place nearly a quarter of a century ago. These doctors found a somewhat sympathetic Fifth Circuit that upheld much of the lower district court's ruling. But then the FDA appeals to the United States Supreme Court, and in this decision, the court dismisses the case, not on the merits. So the court says nothing, it's a 9-0 decision. The court says nothing about the safety and efficacy of mifepristone, which has been beyond proven for decades now. Rather, they dismiss the case on standing grounds, right? So in order for a plaintiff to get before a federal court under the Constitution, among other things, that plaintiff must have standing. So what is standing? Basically, it's the idea, right, that the plaintiff must be able to show an injury or an imminent injury that is caused by the defendant's conduct. In this case, so basically, standing requires a plaintiff to show that they're not a mere bystander of the defendant's conduct, but they have skin in the game. And what the Supreme Court said in this case was that the pro-life doctors and pro-life activists who were suing the FDA, they were mere bystanders. They didn't have skin in the game because federal law already doesn't require them to play the game. So what do I mean by that? I mean this. Shortly after Roe was decided, Congress responded and states responded with laws that basically told doctors and other medical personnel that they didn't have to perform abortions and they couldn't be fired for choosing not to perform abortions if abortion violated their deeply held religious and moral conscience, right? So there's a whole slew of very robust federal and state conscious protections for doctors. So what Kavanaugh, who wrote this decision in the standing case, said, look, federal conscious protection already doesn't require these doctors to participate in any abortions. They were trying to argue that they had standing because it was a very far-fetched theory of standing that both the district court and the Fifth Circuit signed on to. And that was this, that the FDA approved mifepristone in 2000, but they did so erroneously because mifepristone can be dangerous. Women taking mifepristone might suffer complications from mifepristone. Those complications might land them in the emergency room. One of these pro-life doctors might be in the emergency room and they might be forced to serve a woman. They might be forced to actually participate in kind of an abortion that goes against their religious beliefs. So the district court bought this very far-fetched theory of standing. The Fifth Circuit bought this very far-fetched theory of standing. And what the Supreme Court says in this case is that no, right, because of these robust federal conscious protections, you don't have to participate in an abortion that maybe was caused, right, or complications from an abortion that perhaps were caused by mifepristone. You can opt out and let somebody else do it for you. So in a nutshell, the court says in this case, you're just a bystander. You don't have any skin in the game. The fact that the FDA approved mifepristone is nothing to you. So that was the mifepristone case. The other case is called...
Before you get to the other case,
Yeah.
you've just set it up very nicely for a law professor's hypo, okay?
Yeah.
So we're about to hear about Moyle versus Idaho, which deals with some of those emergencies.
Yeah.
So try to imagine that we're in Idaho, and one of these religious doctors is there, and someone does in fact come in with some complication from mifepristone, and he's the only doctor, or she's the only doctor there.
Yeah.
Then what?
Well...
Now you can explain the second case. to
Okay,
everybody.
so Moyle versus United States is a case about a conflict between two laws. What are those two laws? Idaho's total abortion ban on the one hand, and a Reagan-era law called EMTALA, which stands for the Emergency Medical Treatment and Active Labor Act. So what do these laws say, and what's the conflict between them? Idaho's total abortion ban makes abortion a crime in Idaho unless it is necessary to save the life of the pregnant patient. EMTALA, this federal Reagan-era law, says that hospitals that receive Medicare funding who take Medicare patients, they have to provide emergency stabilizing treatment to people who come into the emergency room, right? So these Medicare-funded hospitals cannot turn patients away, including patients who are in active labor, as the name of EMTALA suggests. You cannot turn them away because they cannot pay, right? So Congress passes EMTALA to address the problem of hospitals turning uninsured patients away. So those are the two laws. What's the conflict? The conflict is there's a gap between them, right? So Idaho's law says no abortions unless they're necessary to save the life of the pregnant patient. EMTALA says the hospital has to provide stabilizing emergency care, right? So meaning they have to provide the care to protect the health of a patient, right? So Idaho's position in this case is that EMTALA doesn't apply here, right? Because in our state, you can only have an abortion, right? A woman can only have an abortion unless it's necessary to save her life, not if it's necessary to preserve her health, including, of course, her reproductive health. The federal government, predictably, is arguing that the Idaho abortion ban is partially preempted by EMTALA to the extent that the ban wouldn't allow the stabilizing care that EMTALA requires, right? So this is a preemption case. The lower courts, the district court in this case, agreed with the federal government. The Ninth Circuit agrees with the federal government, although there wasn't a full judgment before Idaho appealed this to the Supreme Court of the United States. So they appealed in an emergency petition asking for EMTALA to basically to be stayed in Idaho pending the litigation. In this case, this Moyle versus United States, it's a 6-3 decision. The court dismissed the case, again on procedural grounds, dismissed it for being improvidently granted, known as a dig. So they said, basically, they dismissed the case as improvidently granted, and they lifted the stay. So for now, emergency abortions in Idaho are allowed in order to avoid the death of the pregnant patient, as well as to preserve the health of the pregnant patient for now. Why did they dismiss it? Why did six of the justices dismiss it for being improvidently granted? It's hard to say. Justice Barrett wrote a concurrence onto which Roberts and Kavanaugh signed, saying that there were certain arguments, that certain things, certain issues that came up during oral argument before the court that gave her pause, that she would like for the case to be for a full judgment to happen at the Ninth Circuit before they weigh in again on this issue. So yes, both of these cases, you might have read in media summaries of these cases that these cases are a victory for reproductive rights. I hate to be the sort of Debbie Downer in the room. I don't think they're victory for reproductive rights. I think, they're just kind of preserving the status quo for now. If anything, I think both decisions actually lay the groundwork for further eroding reproductive rights down the line. Both of the decisions, as Carrie just said, really are really signaling to the Biden administration, right, which, is sympathetic to abortion rights and disagreed vehemently with Dobbs. They're signaling this. Look, you might try to get around Dobbs, but you cannot get around federal religious conscience protection for doctors, right? So you might require hospitals to to provide stabilizing care to women, which might include, abortion care, but doctors in those hospitals can always opt out, right? And this case, the Moyle case, goes pretty far, goes even further by suggesting that they can opt out. At least 3 of the justices made this suggestion that they can opt out even if there's no one else in the hospital willing to perform, even if there's no one else in the hospital willing to give a woman stabilizing care to preserve her health in the event of a health emergency.
Thanks. We have a lot of cases to do, so I don't want to pursue this much longer, but you might just, all of you out there, think about something that Courtney mentioned. We're so glad you're here because you're beginning to hear how complicated this is. And the journalistic headlines sometimes oversimplify these cases. So those of you that are lawyers in the audience, you understand this, but those of you that aren't, be careful when you read those headlines. And I'll just suggest that some have suggested that some of this effort to not really decide these cases and make Dobbs even worse is because we are in an election year. So just think about that. So now we're going to move to what is a pretty technical area for lawyers, but pretty significant for all of us. And that is, as many of you have heard in the rhetoric during the election season, the complaints that many Republicans have about our administrative state. This court has done severe damage, I would say, to the administrative state. We've got about 4 or 5 cases this term that deal with it. We're going to start. Erwin's going to comment on Loper Bright Enterprises, which overruled a long-standing, over 40-year precedent of Chevron deference to what administrative agencies do in the way court reviews regulations. And you've already begun to hear about some of the regulatory cases this term. So Erwin, tell us about Loper, and then if you want, without preventing us from getting to Trump, that I know everybody's here to listen to, if you wanted to talk about EPA or some of the other regulatory cases. Go ahead.
Let me just start by saying how wonderful it is back home at UCI. Thank you so much for inviting me. I also want to say a word to echo the theme you started. If I was to have a theme of this term, it's a court divided. I counted this morning, there were 59 decisions this term, opinions after briefing oral argument. 23 of them were 6-3, and 5 of them were 5-4. And even in cases that were unanimous or nearly unanimous, there were so many opinions. Rahimi was 8-1, but there were 6 opinions. Also, the tone of the justice in some of the cases was much more rancorous and angry. I once read that someone described the Supreme Court as 9 scorpions in a bottle. I would describe the court this term as 9 angry scorpions. In terms of administrative law, I so agree with Carrie that one of the most important changes in the law during the Roberts era has been cutting the powers of the administrative state. In the last couple of years, the Supreme Court created a brand new doctrine to limit the power of administrative agencies, the Major Questions Doctrine, that said that an agency can act on a major question of economic or political significance only if there's clear guidance from Congress. The court used it 2 years ago to say the EPA couldn't regulate greenhouse gas emissions from coal-fired power plants. The court said last year that the Biden administration couldn't give student loan relief. Ask yourself the following: what's a major question of economic or political significance? What's enough congressional guidance? The Supreme Court hasn't said, so it's opened the door to challenges to every kind of agency regulation. I spoke in DC last fall, and lawyers said to me, our clients think everything is a major question and want to bring a challenge. Now the Chevron doctrine. In 1984, in Chevron USA versus Natural Resource Defense Council, the Supreme Court said when a federal statute is ambiguous and an agency is interpreting it, courts should defer to the agency interpretation. Example, the Clean Air Act says that the Environmental Protection Agency can regulate air pollution. If the EPA decides only a certain amount of a particular pollutant for the air, courts should defer to the agency with regard to that. Chevron deference about the idea that the agencies are experts and Congress can't legislate with great specificity. Chevron was a unanimous decision 40 years ago. But last Friday, the Supreme Court, in a 6-3 decision, expressly overruled Chevron deference. Chief Justice Roberts wrote for the court. Justice Sotomayor wrote a blistering dissent. Chief Justice Roberts said, under the Administrative Procedures Act, it's for the court to interpret the statute. No deference is to be given to the agency interpretation of the statute. Justice Sotomayor talks about how this is just an enormous change in the law. They'll put in jeopardy health and safety regulations, regulations of the environment, regulations of business. What will it mean in practice? Well, the reason that business has long wanted to overrule Chevron deference is to make it easier to challenge government regulations in the court. And I think you're going to see an enormous increase in challenges to government regulation in the courts and many more government regulations overturned. The day before, the Supreme Court decided another case that limited the administrative state. There's a case called Securities and Exchange Commission versus Cherkesy. Federal law says that the Securities and Exchange Commission can impose civil penalties when somebody violates federal security laws. Cherkesy and his business were accused by the SEC of violating federal securities law. It went before an administrative law judge. The judge found a violation. $300,000 in penalties were imposed. The Supreme Court, once more, 6-3 reverses. Chief Justice Roberts writing, Justice Kagan writing a vehement dissent. And Chief Justice Roberts says, agencies can't impose civil penalties. If there's a desire for civil penalty, it has to go to federal court, where there's a possibility of a jury trial with the Seventh Amendment. But as the dissent pointed out, there are over 200 federal statutes that authorize agencies to be able to impose penalties. All of these are now of questionable constitutionality, and it goes beyond that. Think of federal statutes that provide for mandatory arbitration, where there's possibility of civil penalties. If an agency can't impose civil penalties, then I don't see how an arbiter can impose civil penalties. So all of this is a tremendous shift of power away from agency expertise and towards the judiciary.
So, since you quoted Justice Sotomayor, Justice Sotomayor has some fabulous one-liners in her dissents. We'll get to one in a moment. But on this one, Justice Kagan said, the court is now hubris squared. Seriously, so what you've just heard Erwin describe, and we see in a bunch of the cases, this court has decided that more and more important questions are only for the courts to decide. And there's a lot of discussion in these cases about who's got expertise. And we have decades of deferral to the expertise of agencies and also to the fact-finding that goes on at the agency level, where we have experts looking at environmental, health and safety regulations, workplace regulations. I worked a lot when I lived in Washington on negotiated rulemaking, where there was deference to the way agencies decided things. And as Erwin says, and as Justice Kagan says, the court is aggrandizing itself as being the only agency court decision maker in all of these cases. And a lot of these cases have this kind of interesting separation of powers theme in it. And I think Justice Kagan and others of us think they are now usurping a lot of other separation of powers, places where Congress or other parts of our government had been the decision makers. Stay tuned for the Trump immunity case. We're keeping you in suspense, just like the court did to us on Monday morning. So I'm now going to turn to a case that I know many of you have probably looked at because it has a lot of local impact here on the West Coast, and particularly in Southern California, Northern California, where all of us are from, and that's Grants Pass, Oregon versus Johnson. I'm going to let Jennifer talk about it, but I can't resist, for those of you who haven't seen it, taking a look at Justice Sotomayor's first line in her dissent, not in the majority. The court now criminalizes a basic biological need, sleep. Jennifer, explain the case to us.
Great. So like you, I'm all eager to hear Dean Chemerinsky's take on the Trump immunity case. So I'll be brief here. So this is another 6-3 decision. It is Gorsuch writing for the court. Thomas with a concurrence that I want to talk a little bit about, and a dissent by Sotomayor, which was joined by Kagan and Jackson. And the case concerns the constitutionality of a city ordinance enacted in response to the presence of unhoused city residents sleeping in public places, both outdoors and in their vehicles. So it's been of interest to a lot of people who are concerned about the plight of unhoused people, about the way that cities and localities and states are managing problems of homelessness in their communities. And so the small city of Grants Pass, Oregon enacted an ordinance that prohibited camping on any sidewalk, street, alley, lane, public right-of-way, park bench, or other publicly owned property. And then it defined a campsite as any place where bedding, sleeping bag, or other material used for bedding purposes or any stove or fire is placed, established, or maintained for the purposes of maintaining a temporary place to live. So prohibits camping. And the challengers attacked this ordinance, and they argued that it violated the Eighth Amendment's prohibition on cruel and unusual punishment. They said what this ordinance does is targets them on the basis of their status, that is, unhoused residents, people who are homeless, rather than on any of the conduct that they perform, any action that they undertake. And they cited to the court's opinion from the 1960s, Robinson, for the proposition that criminalizing somebody's status as opposed to conduct that they engage in is unconstitutional for purposes of the Eighth Amendment. Robinson had involved a California law that made it a crime to be addicted to drugs. Lawrence Robinson was convicted under a statute that made it a crime to be addicted to narcotics. And the court in Robinson held that that statute violated the Eighth Amendment's cruel and unusual punishment clause because it criminalized his status as an addict. It didn't matter what he did. He could be convicted of a crime for being an addict. The court made it clear that the state can criminalize conduct relating to status, so selling drugs, buying drugs, using them, but not being an addict. A few years later, in a case called Powell, a Texas man challenged his criminal conviction on for public drunkenness, and he argued that this was also a criminalization of status that violated the Eighth Amendment. And in an opinion by Justice Thurgood Marshall, the court rejected that challenge. They said the law in question criminalized conduct, being drunk in public, not status, the status of being an alcoholic. Justice White concurred, and his fifth vote was necessary to the outcome of the case, and he clarified that if there was a showing that Powell had no control over being drunk in public, that is, he had no home, nowhere to go, then that would violate Robinson because it would effectively conflate status and conduct. But he said that wasn't the case here, we don't have that showing, so in this case it's okay to criminalize his public drunkenness because we're criminalizing his conduct. And Grants Pass was really a question that sort of is in that space, I think, that Justice White is writing about. Justice Gorsuch, for the majority, said that the ordinance criminalized conduct, camping in public. He says it doesn't target the status of homelessness. It's broadly applicable to anyone who engages in prohibited camping in public, student protesters, backpackers, and people who lack housing. The majority opinion doesn't overrule Robinson. It purports to apply it. But it's worth noting that Gorsuch's opinion engages in a lot of criticism of Robinson about its Eighth Amendment roots, et cetera. And it's not really clear, given the holding of the case, why that's necessary, since they say it's distinguishable. But this seems to be sort of an effort to really weaken the underpinnings of Robinson. Justice Thomas's concurrence, in fact, urges reversal of Robinson, says it's wrongly decided, says the Eighth Amendment doesn't actually include any prohibitions on the kinds of conduct that, or what states can criminalize. So we should just put a flag here to note that there are justices at work in undermining and weakening what Robinson stands for. And we've seen this before, where courts distinguish a case out of existence before they explicitly overrule it. I think that's part of what's happening here. Sotomayor passionately disagreed with the distinction that Justice Gorsuch created between this case and Robinson. She read her dissent from the bench. She, as you said, sort of pointedly started out by noting that this effectively criminalizes people for sleeping, which is a basic function. She reaffirms the basis for Robinson, and she argues that this case really is sort of what Justice White flagged in Powell as something that is protected by the Eighth Amendment. That is, when there are no choices involved for these individuals, when they are being targeted because of their state of being unhoused. This is not a criminalization of conduct, but it is a status criminalization. And she really digs into what is happening on the ground. She says, yes, it says camping in public, and Gorsuch says that could apply to backpackers and student protesters, but she notes that the definition of camping talks about the camping functioning as a temporary home, which is really only the case for people without a home, and not student protesters or backpackers. And she also showed that functionally in Grants Pass, the only people who were being subjected to the ordinance were individuals who were unhoused. So both as a practical matter and as a definitional matter, this really does seem to target individuals who are homeless and not more generally people who are camping. It's notable that even under her dissenting opinion, states could criminalize the setting of fire for warmth. They could criminalize public urination. In other words, the court is united in the notion that much of the conduct associated with the conditions of being unhoused is criminalizable. Where they're differing, though, here is, Sotomayor is sort of saying there's a point at which this has to stop, and sleeping is that point. What the Gorsuch opinion for the 6 justices of the court mean is that now that too is criminalizable. In many ways, I think the biggest takeaway from Grants Pass is the majority's effort to sort of undermine, doing the most about undermining Robinson without overruling it and raising questions about whether status criminalization is something that will be back on the table, at least not prohibited by the Eighth Amendment in the wake of Grants Pass.
Can I ask a question, Carrie?
Sure.
Because I don't teach it anymore, but Erwin and Jennifer, wasn't there a California case that from LA Skid Row that criminalized the sitting on the curb or between certain hours that went to the court, and ultimately the court decides because people can't help, if they're homeless, can't help but need to sit down at some point or to rest, that you'll know the case.
It was a Ninth Circuit case, Jones versus United States.
Okay.
Never got
and
to
then
the
it never went to the court. And then there was Martin versus City of Boise in 2018. Where the Ninth Circuit said you can't make it a crime to sleep in public if people have nowhere else to go. Right. And then Grants Pass was relying on Martin versus City of Boise. And my favorite line from Justice Sotomayor's dissent was, what this means is stay awake or be arrested.
Right. I love that one too.
Okay, I was bothering. It's Ninth Circuit.
Yeah,
That's what
And that was where
that's
Grants
why-
Pass was
and
coming
the court,
out.
in talking about Grants Pass, talks about how much of the law was made in the Ninth Circuit. They act as if we on the West Coast are the only ones with homeless problems, although it's interesting, the case says, I don't know if this is accurate, this is an empirical question, 75% of all homeless people are on the West Coast, says the decision. Some of you may have heard about this on the local news because Los Angeles has not passed, the city of Los Angeles has not passed an ordinance like Grants Pass, and some of you may know this, this is relevant in Orange County too. There was a lot of talk in the media again about the effects of this locally as some jurisdictions will now start dumping their homeless populations in places where they won't be criminalized, that is Los Angeles. So stay tuned for debates at city council levels and watch how localities respond to this case.
San Diego, the mayor is attempting to get such an ordinance passed. And
Sure.
one of the parties that's pushing back, and I agree with him, are veterans, because in San Diego, a significant disproportionate amount of the homeless population are actually veterans.
When I was here, Laguna Beach adopted an ordinance like the Grants Pass one that made it illegal to sleep in public, and Laguna Beach was regularly taking its unhoused population and busing them to Santa Ana. And the ACLU, and I was co-counsel in the case, brought a lawsuit that Laguna Beach settled and rescinded the ordinance. I imagine we're going to see that city and others adopting them.
I want to turn now, very briefly, because after this we're going to get to Trump, to 2 speech cases. So we'll start with Erwin, if you want to comment a little bit on Murphy versus Missouri, and then we'll turn to Kelly on the net choice cases. So if you guys could both tell us a little bit about, comment and keep it brief enough so our audience can get to hear about what we all think about Trump's immunity. Erwin.
When is speech by a government official enough to chill the speech of others and violate the First Amendment? At the beginning of each year as a dean, I sent a message to the school saying to the students, talk respectfully to one another. Use civility. Don't engage in hateful speech. And students sometimes object and say, you're chilling my speech. Is that violating their First Amendment rights? Well, Worthy versus Missouri involved that issue. What here was a claim by 2 states and 5 users of social media that the Biden administration, by encouraging social media platforms to take down false speech, had violated the First Amendment. And the district court and the United States Court of Appeals for the Fifth Circuit agreed that pressure from the government to take down false speech about vaccines or about the 2020 election infringed the First Amendment. The United States Supreme Court reversed the Fifth Circuit and did so on standing grounds. The court said, in order to be able to sue in federal court, you have to show an injury that's caused by the defendant and where a favorable federal court decision is likely to remedy it. The court said, there's no showing that it was the government's pressure that caused any changes with regard to the social media platforms and what they included. In the absence of such a showing that the government caused false speech to be taken down, there wasn't standing and the case had to be dismissed.
Very well done, Sarah. See?
Very quick.
Great teacher, great summarizer. Thank you, sir. Kelly, so tell us about net choice.
Okay.
Another case of punting, one might say, yes?
Indeed. So net choice, I think this one's interesting because it's a 9-0. So maybe you look at it and say, oh, there is consensus on the court, but I think it's very clear that there is not, and that there are very differing views about First Amendment, particularly in the internet platform context. So net choice is 2 cases challenging Texas and Florida laws that were passed to restrict content moderation by platforms. And very transparently in response to Trump being removed from Facebook and Twitter. And NetChoice is a trade association that includes Facebook, YouTube, but also, which will turn out to be important, companies like Uber and Etsy. So the 11th Circuit says content moderation is First Amendment protected editorial discretion. The Fifth Circuit says the opposite. Content moderation is conduct, it's not expression. And what the Supreme Court says is, okay, well, this is a facial challenge, so that means we need to look at kind of the ratio of constitutional applications to unconstitutional. We don't have enough information to do that here. And so, what does this mean for an Etsy? Is that First Amendment speech? Sure, maybe for a Facebook news feed, content moderation might be editorial discretion, but not necessarily in all applications. We need to send this back. I do think there are probably 5 judges who would say content moderation in the context of a Facebook news feed would be protected by the First Amendment, but they don't make that decision now.
Stay tuned. I'm about to, we have plenty of other cases to talk about. We'll come back to them. I'm about to turn to why many of you are here, and that is Trump's immunity case. But one might just ask, as you hear about all this, those of us who teach this stuff, technically standing, all of this stuff, very complicated jurisdictional questions. An interesting question of why, I don't know if you counted or when I did a little bit, whether this term had more cases that were remanded for more fact-finding, certiorari improvidently granted, or it's not quite ripe enough yet, they didn't use ripeness so much. The court really used a lot of these doctrines, which exist, to avoid deciding a lot of these cases. And as I've alluded to before, did they know in advance that they were not going to be deciding these cases? Why did they take cert? Or is it the fact that we're in an election year and they were trying to be careful a little bit about what they did? You want to say something, Mario?
Yeah, I think there are times historically where the court does get ahead of itself on granting cert and then realizes when they get the sort of full measure of the case that it's improvidently granted, or that they can agree to a narrow reason, usually procedural, and it avoids all the conflict over the underlying substantive issue. Yeah, I do agree. Many people say, well, if you were going to kick it for why even grant cert to begin with? Because
well, we're beginning to see what all the arguments are, right? Sure. And that, of course, that adds to even more amicus briefs when they finally get there, as all the various interested parties muster their arguments. Okay, And so now, the reason you're all here, well, you may be here for many reasons, but we've kept you long enough to be in the weeds of all of the complicated decisions by the court. We'll turn to the two cases involving Trump's behavior. We'll start with the big one, which came down on Monday morning, and that is U.S. versus Trump, Trump's immunity, presidential power. So
I'll start.
You want to start, Mario, and then we'll have Erwin.
I'll give the factual background and a very little sort of commentary and then open it to Erwin, which is, I think most people know that after the election of 2020, Trump engaged in a pattern of conduct in which he basically denies the results of the election and attempts to obstruct the counting and certification. And ultimately, it leads to a federal grand jury indictment on 4 counts criminally. And what happens, he and his team go into a district court in DC and challenge that he has broad and absolute immunity from criminal prosecution based on actions taken while president. That is rejected by the district court in DC. It is also rejected by the DC Circuit Court. Interestingly, they did not decide the question of whether the underlying conduct was official or not. So that question they didn't answer, but they did answer no to the question of absolute immunity. It comes to the High Court and a 6-3 opinion written by Justice Roberts, to which I think there are compelling and cogent responses from both Justice Sotomayor and Justice Brown Jackson. So the long and short of it, and this is half glass full for a lot of people in the press on it, was this distinction between official acts of the president and unofficial acts, and those things for which he enjoys a broad immunity, and those things for which he does not, and what happens potentially for those things are unofficial. So in some ways, people were selling, well, he didn't get full and complete immunity. There is this distinction, but I think if you read the language of the majority opinion, it's frightening. Because what it says is he, in a sense, does enjoy a type of absolute immunity and a presumption to it for a set of activities that it describes even within the outer perimeter of the things for which he enjoys official responsibility. And they do clarify it's things for which there is a specific constitutional commitment of executive power. He might enjoy less immunity for shared responsibility items for which it's the president and Congress. They also go on to tell us that now district courts are going to have to figure out what is official and unofficial, but they caution them to be careful, because they seem to suggest that even things that seem to be remote from presidential power could be covered, so much so that they suggest that you're going to have to be careful that none of the evidence you try to admit against the president, even one who is acting unofficially, not touch on any of their actual executive power. And so, I mean, even though there is this distinction between official and unofficial, I find the language sweeping, right? If you think about a case like Nixon, where the president made a claim about absolute immunity in the context of privileged communication, and the court says, absolutely not. What you enjoy is a qualified immunity for a subset of communications, especially for things that are national security and the defense of the nation. There's no such qualification here. It's sort of official, unofficial. We will broadly interpret the things that are official, and now we're going to kick it to the lower courts to start doing that work. What each of the dissents do that people sort of took issue with is give these very horrifying examples that could actually be immune from prosecution, and Justice Roberts says they were fear-mongering. And this is one where I think you think about the justices just living in two different worlds. But I'll turn it to Erwin.
But before Erwin, I'm going to just say two quick things. I always tell my students, I bet these guys all do too, if you want to get a sense of what it's like to live in alternative realities, read a majority opinion and read a dissent. And in this term, we have a vast literature on that to see that justices on different sides of these literally live in different worlds. As law professors, ever since this case came down, all of us have been generating, as the court did, all the hypotheticals that come off of this case. So we can talk about the fear-mongering ones, but just take from the Nixon era, some of you know. When Nixon was president, he asked the IRS to target his enemies for tax audits. Is that covered? Is that an official oath?
Yes.
Yes. Go ahead, Erwin. Take it away.
I very much agree with Mario's description. Let me just say a little bit more about what the justices say, and then to say a word about what I think of the decision. Chief Justice Roberts seems to draw a distinction among three kinds of presidential acts. One would be official acts, and he defines official acts as anything done in carrying out the constitutional powers of the president or anything done pursuant to statutory authority. And he says the motive of the president doesn't matter and shouldn't be looked at by the court. Then he says there's a zone of activities that are at the outer reaches of the president's authority. And he says for that, there's presumptive absolute immunity. And then he says there are the private acts of the president, and for that, there's not absolute immunity. And he tries to use that as a reassurance towards the end of the opinion. Well, think about what the indictment was about by Jack Smith. One part of it was the misuse of the Justice Department to try to undermine the 2020 election. The court is clear that that's protected by absolute immunity because it's communication with the president and the Department of Justice. President Trump trying to get Vice President Mike Pence to give him the election when the votes were cast. The Supreme Court says, well, that's unclear, but that seems to be in the presumptive category. What about President Trump pressuring state officials, like in Georgia, to find votes for him? Or what about what President Trump said on January 6th? The court said it was going to remand that to the lower courts. But I thought it was telling that the court didn't on its own say that's in the private category. What about the convictions in New York? You might have seen the news this morning that there's an agreement to delay President Trump's sentencing to allow him to argue absolute immunity. I don't see that as even possibly within the official or the outer boundary. That seems so clearly private. It's asking that business ledgers be falsified to hire. So I think it's frivolous to say that that's protected by absolute immunity, but we'll see. As Mario says, both Justices Sotomayor and Jackson write blistering dissents. Justice Sotomayor does give the example. She says, what if the president orders Navy SEALs to go kill political rivals? That's the president as commander-in-chief. Core constitutional power. Motive doesn't matter. The president choosing to use the Justice Department for political retribution, to prosecute rivals. That's clearly protected by absolute immunity. The president taking bribes to give pardons. A core power of the president is being able to issue pardons. So all of these, Justice Sotomayor says, quote, immune, immune, immune. I thought that Justice Jackson, in a footnote, very powerfully put this. She said, there's no doubt that the president has the power to fire the Attorney General. The question is, does the president have the power to poison the Attorney General? And this would say absolute immunity. So I think that in hindsight, this will be on the list of the worst Supreme Court cases ever. And I know it sounds like hyperbole the day after the decision.
Well, they had to replace Korematsu with something.
Oh, no, I didn't say at the top of the list.
Plessy, you forgot Plessy,
Dred
my
Scott,
friend.
Plessy, Korematsu will be in the Hall of Shame forever.
Yeah.
But so will this case. And that's because the very core of the rule of law is that no one, not even a president or former president, is above the law. And what this says is that the president, in using constitutional powers, no matter how much it's illegal, no matter how much it's an abuse, has immunity, I think, for both criminal and civil liability. That can't be reconciled with the most basic principles of our democracy.
And as Sotomayor said, what this court has now done is made the president the king. A little appropriate before July 4th for us to consider what that actually means. So let's just spend a moment or two before we close on the other Trump case, and that is U.S. versus Fisher, which had to do with the indictments of several of the January 6th insurrectionists. Erwin, do you want to summarize for us?
Sure, I'll do this quickly. The Sarbanes-Oxley Act that was adopted in 2010 has a provision that says that it's a federal crime to impede or obstruct official proceedings. And this was one of the counts in the indictment of those who were prosecuted and convicted in federal district court in Washington, D.C. The Supreme Court, in a 6-3 decision, but not with the usual split among the justices, found that this statute is limited to engaging in obstruction or impeding that relates to documents. That's really what the Sarbanes-Oxley Act is about, is something that relates to records, documents, that they won't read the so-called catch-all provision in the way in which the literal language would suggest. What's interesting here is Justice Barrett wrote the dissent, joined by Justices Sotomayor and Kagan. So what does it mean? Well, for all of those who were convicted after January 6th under this count, this conviction is likely overturned. But all of those who were convicted on other counts as well. So it's not likely to mean that any overall convictions are reversed, but resentencing. And in terms of this count of the Trump indictment, if it's not protected by absolute immunity, I think there's an argument that President Trump was trying to change how the ballots were counted, and that goes to documents, so maybe the law can still be applied. But it's a narrowing of the federal statute to say this just applies with regard to documents, records, not just obstruction of a proceeding.
Thank you. So we're getting near the end of the program. We have other cases on our list, so I just wanted to mention quickly a couple of them. Jennifer was going to talk about Department of State versus Munoz, which some of you may know of as the tattoo case. An American citizen had her husband, who was living out of the country, apply to a visa to come join her. And simply because he had tattoos that may or may not have been gang-related, he was denied a visa, no procedural rights of any kind, and the court sustained that finding. Similarly, I just want to quickly mention one close to my sad heart. Some of you may have read about that one, and that is Harrington versus Purdue Pharma. And some of you may have read about that. There was a major settlement with Purdue Pharma for the opiate abuse by the Sackler-owned company. And the Justice Gorsuch essentially stopped the large multi-billion-dollar settlement. And I just wanted to mention that one because some of you may, in fact, have people in your family that were going to get compensation for opiate abuse. Billions of dollars of that were going to be allocated to state and localities to develop treatment programs. All of that's on hold now. Interestingly, I just mentioned also, because it is another example of one of the few times in which the otherwise conservative members of the court split. On that case, Justice Kavanaugh wrote, I believe, a quite very good and thorough dissent, because like me, he was concerned about the practicality of what the effect of thwarting that settlement is. Hundreds of thousands of people are probably going to suffer a great deal. It may get renegotiated. It's not the end of the world necessarily yet. The reason is that the Sacklers themselves as a family were let off without any liability as the company was planning to pay for all the settlements, with $6 billion of Sackler money still going into the settlement fund. So that's a case that has enormous impact on lots of people and very complicated bankruptcy law with statutory construction. So again, if you have an interest in that, you might want to take a look at it. We have like 2 minutes left. I'm going to read one question. We don't have time for all of them from the audience. If anyone wants to comment on this question. After listening to all of this morning, is there anything that anyone can say that's hopeful about the future of the court? Anybody want to take that on?
Was that the question?
That's the question. What can we be hopeful about in the future of the court?
Oh, in the future of the court. Oh.
The court.
So it's a thin hope, and I simply say, we saw in this alliance of the three dissenting justices, that I do think the rise of a powerful counter voice that actually is speaking for people who are not represented in many of these majority opinions. It reminds me a little bit of Marshall in the end, Brennan and Marshall, in which people took the futility sometimes as sort of the point. I actually take the willingness to continue to press the counter argument for the hopeful day when you will no longer be in the dissent.
Thank you, Mario. That's very inspiring. That was also done by my good friend Ruth Bader Ginsburg at the end. I forgot to bring my I dissent mug, but absolutely, and as any of us up here who taught constitutional law can tell you, the dissents of today, hopefully, will be the majorities of the future. We can only hope for some of us. Erwin, anything you want to say?
I think the late Dr. Martin Luther King Jr. got it right when he said the arc of the moral universe is long and it bends towards justice. that I think that many of the decisions we've talked about will come to be overruled by a future court. I think the question is, how long until we get to that future court?
May we all live so long.
May I still be alive?
Yes, may we all still live so long.
I think the other thing to keep in mind is that, you know, if you think about a case like Grants Pass, yes, it removes constitutional protection for sleeping in public, but it doesn't remove our ability to advocate with our local officials or our state officials for humane policies on unhoused people. It doesn't stop our ability as, you know, as democratic actors to participate in many ways to protect the rights of people who may be disenfranchised or marginalized, and that struggle is really important. So I think it's important not to be demobilized by what might be viewed as a depressing term from the court. There are still many, many spaces where democratic participation is important and where it can really make a difference, and I think it's important to remember that walking out the door.
Thank you so much. And if I can do a little 4th of July commercial message, get out and vote, everyone. Thank you so much for being a great audience. Happy 4th of July. Thank you. Thank you to our wonderful panelists. We have a short reception in the lobby for about half an hour, and Erwin and Jennifer will be out there signing books. So if you want to do that, get out there fast because they have to leave us. Thank you all so much.
Thank you.
Thanks so much, Sean. Thanks.